Hi everyone, in this week's dispatch we are starting a two-parter on criminal convictions, DBS checks, the Rehabilitation of Offenders Act, and how all of that interacts with the employment relationship and employment law. So as an employer, you may carry out checks with the Disclosure and Barring Service or undertake DBS checks. In addition, or as an alternative, you may have an application form or build into your recruitment process questions around whether an employee has any normally unspent criminal convictions, and we'll come on to what we mean by spent and unspent. The legislation which tends to govern convictions in the context of employment law is the Rehabilitation of Offenders Act 1974. So that legislation aims to strike a balance between the recognition that people can be rehabilitated and they are able to move on with their lives and contribute to society. That is weighed up and balanced between the need to have disclosure in certain situations and protect certain groups from those who've committed certain offences. Depending on the nature of the offence, there is a period of time called the rehabilitation period when a conviction remains unspent, and that depends on the seriousness of the offence. After that rehabilitation period, the conviction is spent, and unless particular limited exceptions apply, the individual is entitled to hold themselves out as having a clean record. Those exceptions tend to be contained in what we call the exceptions order. So in very highly regulated environments, or where individuals might be working with very vulnerable individuals, there may still be an obligation to disclose spent convictions. The majority of this video and the next will not deal with those circumstances, but ordinary employment. During the rehabilitation period, when an individual has an unspent conviction, there will generally be an expectation and a requirement to disclose those convictions in response to a request for details of criminal convictions. So as we said, different offences will have different different rehabilitation periods. A custodial sentence of over 4 years or a public protection sentence will never be spent, so it will always show up on a DBS check, and an employee will generally always have an obligation to disclose that. In the middle, a custodial sentence of over 6 months and up to 2.5 years is spent after 4 years. And at the lower end of the scale, a fine will generally have a 1-year rehabilitation period attached to it. As we say, spent convictions don't generally need to be disclosed to the employer. If you are falling on part of the exceptions order, that will be a little bit different. Unless an exception applies, the effect of the 1974 Act is that a person questioned cannot be subject to any liability or otherwise prejudiced for failing to acknowledge or disclose a spent conviction. So it's not permitted to refuse to hire somebody or refuse to offer them promotion simply because they have a spent conviction. And during the employment relationship, failure to disclose the detail or existence of a spent conviction, again, unless the exceptions order applies, is not a lawful ground for dismissing or excluding any person from office. So we cannot dismiss somebody simply because they haven't disclosed a spent conviction. There is a 2-year qualifying rule for an unfair dismissal claim on that, however. Now, what happens if we want to refuse to employ somebody who has a criminal record? Now, part 2 of the video will come on to a sort of risk assessment process and factors we might want to consider in determining whether to employ somebody. Essentially, we need to exercise our judgment, regardless of how we've come across the information. There will be a number of factors that are relevant to acting on that knowledge. As we say, if a conviction is spent, we are generally not permitted to refuse to exclude somebody from employment. In saying that, however, there is very limited or indeed no redress in employment law for somebody who is not recruited in these circumstances. So we could well face a position where we legitimately identify that nobody has any unspent convictions, maybe because we've conducted a DBS check, but information comes to light that suggests there are spent convictions on an applicant's record, and we deem that makes them not desirable to recruit. Well, in those circumstances, whilst the 1974 Act says that we are prohibited from taking into account a spent conviction as a ground for excluding somebody from recruitment or an application process, in reality, there's no punishment for that offence and there is no remedy for the employee, unfortunately. And that may be a factor that you take into account when making recruitment decisions. As I say, the second part of this video will then focus on other factors that we really should be considering if we do come across spent or unspent convictions, factors to take into account when determining whether to proceed with the recruitment exercise. And they'll also be relevant to the circumstances of potential dismissal as well. So tune in for part 2 in due course. If you need any further information on this subject area or anything employment law related, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.